This post is for the attention of the ATAC, a bit of a play on the old Schoolhouse Rock classic Conjunction Junction. What we've done is borrowed the theme and reposted it as Injunction Junction. What this is following on is the pardon application. So we'll start with a look at the life cycle of an alleged offense, assuming there's no acquittal. So what we're through is the rehabilitation phase, and now looking at this record suspension guide. So this is just another one of the hurdles that any document holder would have to face at some point in time. So anyway, somewhat problematic with all that's come and gone since 2001. So we're wrapping this up with a pardon. And you can see from inside it says when can you apply, and this is after a waiting period and after any probation orders have been satisfied, and it also has this rehabilitation form attached. So from the holder's perspective, we're looking at the medical treatment the probation officer feels is required, and any meds is directed by Dr. Albrecht or Dr. Elwell. And that has to be completed prior to the waiting period nominally. So included here is Dr. Bland's review going into 2004. As well, looking back on the case history, you can see it talks about a diagnosis might not be advisable, and then turns around and discusses future observations after a considerable period off meds. So somewhat contradictory, and doesn't match Dr. Singh's conclusions. So that's why there was a civil action over TC's refusal and the notes listed here. So included for Dr. Albrecht would be TP 13312E and some of the issues regarding the medical ethics of any meds as directed. So, which takes us back to Injunction Junction and look at putting the case on a different track while the option is still available. So going back into the documentation, this rehabilitation form brings up Wikipedia's definition of rehabilitation to restore to good condition, operation, or capacity. So although Dr. Woods was named in the suit, it's actually Dr. Bach where this first appears from Feb. 02, forced to take meds, stabilized with meds, can no longer work as a pilot. So that's just the opposite of returning to service. So what we have here is the injunction issue and a certificate of readiness, and these are really lessons learned from QB Civil. So we'll draw up Justice Manderscheid's determination here, and some of the reasoning talks about the standard of care established by law, which is iffy. The injury or loss is TC's refusal, but the actual conduct for the physician is, of course, very difficult to pin down. And further in the page, it talks about legal liabilities of doctors and hospitals in Canada and the same medical specialty as the defendant, which basically raises Dr. Bach as well. So one of the main concerns here is we're always working in hindsight, waiting for the Richard determination, Manderscheid, or even Judge Birch back in 02. So what we have, though, is a look at this administrative law and practice, and it talks about the retrospective nature of certain determinations as well as limitation periods. But the reasonable explanation for the delay would be Dr. Bland's considerable period. So included as well in this book is a judicial review for the duty of fairness, discussing Dr. Bland at TACTI, for instance, and speaking to this observations, as well as for Dr. Bach, criminal prosecution, call evidence, examine witnesses, and the overall presumption of innocence. But it's water under the bridge now. So anyway, what is current is this application guide, and it talks about completed all the sentences. So Dr. Albrecht, follow-up and consultation, etc. And here we see a draft of the measurable benefits form in Acrobat for the recipients, and Transport Canada's letter of recommendation with various regs and flight safety points annotated out. Dr. Bland's review, which was never adequately challenged at TACTI or in QB. And as well, the purpose of this post is some information on obtaining an injunction. So it talks about various tests in law, and of course there's always rules of court and such to consider on the applicant's nickel. So this is a bit of a reference. Varies by province to province. Any good lawyer should be able to figure this out. And what we're drawing eyes onto is this approved OTC meds, as well as some of the tests in law about demonstrate a need and demonstrate irreparable harm if it is not granted. So pinched from this User's Guide to Injunctions and Related Remedies, we have various tests. It shows a serious issue to be tried, and I would call this the prior training in aviation medicine. TACTI's page 74, and then greater harm, etc. So while we're drawing eyes onto this, from the administrative law, we have something on advocacy before the tribunals, and which you might have to guard against, which is issues such as the PIFCO docket, perhaps moving ahead to nothing new has been submitted, and various reports to 1985, and Dr. Bland again at TACTI, as well as his reporting and disorder, which we're contesting. So we have Dr. Bland summons, as that's part of the judicial review, and TACTI's page 74, which is no surprise, but that matches Dr. Solerator's aviation medical. So we'll just close the theme with the idea that a stitch in time saves 9, and with all the documentation and paperwork, perhaps preparing an injunction going in would be the answer.